Welcome to Case by Case. This is a podcast brought to you by Floyd Zadkovich. This is Callum Chain. I'm Luke Zadkovich.
Every episode, we read a case independently of each other. We jump on the podcast, we hit record. So what you get is our raw thoughts on that law.
And we're super excited with some of the guests we've got coming up on future episodes. So keep an eye out.
And if you like the podcast, all we'd ask is that you hit subscribe and share with your network. Okay, let's get into it.
Let's do it. Welcome to Case by Case. This is a podcast brought to you by Floyd Zadkovich. I'm here today on my own, without my partner Callum Chain. I'm Luke Zadkovich, but I am happily joined by two of my colleagues on my right. We've got Andriy Shalennyy, one of our associates here. How are you, Andriy?
Hi, Luke. It's a pleasure to be here. I'm very well. Thanks very much for inviting me.
Great. Good. And on my left, we've got Emmanuel Michelakakis-Howe, who is a barrister on long-term secondment here at the firm from Lamb Chambers. Welcome. Now, we've got a great case to talk about today. Very much looking forward to getting into it. It's all about the damages that an owner is entitled to when a charterer redelivers a vessel late on a time charter. So looking forward to getting into that. In many ways, I would have thought this is quite well settled law. We've got decisions going back for a century on this topic, but we found a point in here to talk about that's new, novel, being described as novel by, I think, the arbitrator, originally. And it's made its way up to the Court of Appeal. This is the case of the Skyros Maritime and Agios Shipping Company on one side and Hapag-Lloyd on the other side. So the appellants and owners are Skyros and Agios Minas, and the respondent charterers are Hapag-Lloyd. And what we're going to do today is something a little different. I won't quite describe it as a mock trial, but we have got two guests on the pod. One, Andriy, who's going to take the position of owners and speak from owners' perspective, who are the appellants, and Emmanuel's going to speak about this case from the perspective of the charterers. So very keen to get into it. Before we do, I just wanted to give a bit of an introduction to each of our guests. Andriy has just finished a training contract with the firm and is now one of our associates in the London office. How's it all going, Andriy?
Thank you, Luke. Well, I'd like to think that it's going wonderfully. I'm enjoying the work very much indeed. So I mostly work with my partners, Jonathan Webb and Callum Chain. So I'm doing a good mixture of commodities work and dry shipping. But recently we got ourselves a very interesting wet shipping case arising from a huge casualty off the South African coast, which is very exciting.
I know that's keeping you very busy along with a bunch of others. So yeah, well, in your wheelhouse today, this particular case. So, I'm sure you've got some interesting insights to give us all. And Emmanuel, what do you focus on, in your practice?
So I work primarily with, Joe's team, Joe Goslin's team, and, Jonathan Webb's team. Lately, I've been working on this big live matter to do with general average and cargo stuck on board the ship, which we act charters in trying to essentially get the owners to let out of the ship and finally discharge. And with Joe, I've had a number of very interesting cases to do with misrepresentations in the context of oil major approvals and issues with damages to cargo occasioned by snails being stuck on board.
Really?
So
interesting one.
It's never a dull day.
Yeah, great. Okay, excellent. Yeah, I think that's fair to say for all of the team here. We're kept on our toes by the work that we've got going on. So I'll just give the citation for this case for our citation lovers out there. I assume that there are these people out there that always write down the citation whenever I do this introduction. I'm sure that's not the case, but we've been doing it for a long time. So, if you want to pull up the actual case itself, here are the details. It is neutral citation number 2025 EWCA Civ 1529. As I mentioned, this is a Court of Appeal decision. It's an appeal from Mr. Justice Bright, and Lord Justice Coulson, Lord Justice Males, and Lady Justice Andrews gave this judgment, and the judgment was handed down on the 28th of November 2025. So a nice recent decision. The two vessels involved here are the Skyros and the Agios Minos, and it was heard in October. So let's get into it. Lord Justice Males gave the judgment. Callum's not here today, but both Callum and I, we always enjoy reading Lord Justice Males' decisions. And this is a nice, I think, succinct, pithy judgment. It gets right to the point. It traverses some interesting territory, of course, but it's certainly a good and easy read through, and I think really gets to the point. So I'm thinking, Andriy, would you like to kick things off and maybe just give some of the background facts on this one?
Yes, with pleasure, Luke. So the way we've been thinking of structuring this podcast was to first start with an introduction into the issue which is at play in this case, and then we'll move on to the relevant facts. And after that, we'll briefly walk through the arbitral ruling and then the High Court ruling, and then we'll finally get to the discussion of the Court of Appeal judgment. So, as Luke mentioned at the beginning, the broad topic in this case was the matter of damages recoverable by ship owners, where the charterer redelivers the vessel after the redelivery date. And the orthodox approach to this question is set out in leading textbooks such as Time Charters, Croton Charter Parties, and Caravan Charter Parties. The approach of those textbooks is pretty much unanimous, and the object of damages, the goal of damages, is to compensate the ship owner for the loss of the opportunity to use the market after the redelivery date. And the normal measure of damages in such a case is the market rate minus the charter party rate. So usually a ship owner would claim such damages where the market has risen after the charter party concluded. And the novel question in this case is whether a ship owner is entitled to the same measure of damages where it has not lost the opportunity to use the market because the ship owner was effectively prevented from using the market in this way.
That's probably quite an interesting point, actually, to take a quick pause on. I think if we take a step back, fundamentally, in every contract, when there's a breach, the foundational sort of viewpoint of English law, the doctrinal viewpoint, has always been just look at the actual consequences. So as opposed to other legal systems, English law doesn't tolerate sort of losses for the sake of them. There's very limited occasions where you can get exemplary damages. Fundamentally, if you want to recover damages, you have to prove that you've actually suffered a loss. And this is fundamentally a really basic point that sort of, every introductory contract law module goes into, right? It's one of the first things people learn when it comes to contractors after offer and acceptance. And it is very well settled in terms of both the foundational principle and the fact that as a proxy for that loss, for what the consequential loss is, the courts have developed over times specific sort of tests or rules of hand as to how that loss is to be assessed. And here, obviously, the very established one is what was called the orthodox approach, as you said, Andriy, that you compare essentially the market rate for the overrun period and subtract the charter party rate, and the owner is entitled to recover that. So that is essentially a shorthand to approximate the loss suffered by owners, I think is the underlying idea. But even though this is obviously a very sort of focused issue when it comes to shipping, when it comes to specific tests, I think what's interesting about this judgment is that the issues discussed in it really go to the heart of a lot of very significant aspects of contract law generally. It's quite generalizable when it comes to some of the arguments. And fundamentally, the question of, well, hold on though, if you haven't actually suffered the loss because you were never going to make use of the opportunity to use the vessel, why should you be able to recover losses on the basis that you might have done so?
I think it's a really good point, Emmanuel. And, I don't mean to double tap it, but I think you're right in that this case obviously deals with a discrete point arising in the maritime context, but even as Lord Justice Coulson noted, there are many other applications for this principle, and we'll get into unpacking what he said in the couple of paragraphs that he gave at the end, agreeing with Lord Justice Males. But this case, I think, does go to kind of fundamental principles of measuring damages in contract law. And for those of you listening in who are not maritime market participants, and I'm conscious that some of our audience are not, what we're talking about here is when you charter a vessel for a period of time. So almost think about it like, hiring a car. You hire a car for a period of time. That period of time is set. And you have to pay a day rate. We call that hire in a time charter context. And there are complicated ways, I suppose, of setting all this out. But fundamentally, the charter has to give back the vessel at the end of the charter period. And that date will be agreed, or arranged for that redelivery will be agreed. And if the charter goes beyond that, and holds on to the vessel for longer than the redelivery date, the question is, how much higher, this day rate, how much higher should the charterer have to pay the owner? Should it continue on at the same rate that they've been paying throughout the charter? Or should it be a market-based assessment where you say, well, if the market has gone up, and now out on the open market, that vessel could charter it to someone else for a higher price, should the charterer be paying that higher market price for the period that they've held onto the vessel beyond when they're contractually entitled to do so? And that's what we're examining today, particularly in circumstances where the owner was not actually going to charter out the vessel to someone else. So it's agreed. We have this as agreed facts, not assumed facts, agreed facts in this case, that the owners were not going to exploit the commercial value of the vessel out on the market. And the question is, do you take that into account or not? So, perhaps briefly we can get into some of the specific facts, Andriy. But I think it helps to kind of paint that overall context.
Yeah, absolutely. So, like Luke said, the arbitral hearing was conducted on the basis of agreed or assumed facts. So in this case, there were two charter parties or two contracts for the hire of two ships. So the Skyros and the Agios Minos. So initially, both charter parties were for a period of 11 to 13 months, the exact period to be in charterer's option. And eventually, the charter period was extended until May 2021, and the latest redelivery date for the Skyros was the 30th of May 2021, and for the Agios Minos, it was the 31st of May 2021. What is absolutely crucial in this case is that before the respective redelivery dates, the owners entered into what is called memorandums of agreement or contracts for the sale of those ships, in short MOAs, by which the owners agreed to sell the vessels to MSC and Maersk. And in this case, the charterers committed a breach of the charter party and they redelivered the vessels after the agreed redelivery date. And during this overrun period, the charterers paid higher at the agreed rates in the charter parties. So there was no question of the charterers not having paid the contractual hire. The only question was whether the owners were entitled to something else, to something over and above the agreed contractual rate. And what is also important is that even if the vessels had been redelivered on time, the owners would not have gone into the market and would not have chartered out their vessels. And in fact, it was a term of the memorandums of agreement that the owners would not do so. So effectively, the owners were contractually precluded from making use of their vessels. And the only way in which the owners could have chartered out their vessels was to effectively breach the MOAs. And of course, in this case, it was not done. Therefore, the tribunal summarized the central issue in this case as follows. That is whether substantial damages, that is to say, damages which are not nominal damages, whether such damages are recoverable for late redelivery under a time charter where there is evidence that after a timely redelivery, the owner could not or would not have chartered it out. So in the arbitration, the parties' positions, well, they were significantly different. So the charterer's position relied principally on the compensatory principle. That is to say that the goal of the law is to compensate a party for its loss. So to receive compensation, a loss must actually have occurred. And the owners actually disagreed with this, and they put forward 3 alternative arguments with which the tribunal actually agreed. So the owners effectively asked the tribunal to disregard the compensatory principle. So the first argument put forward by owners was that the owners were entitled to that additional hire under something called a quantum merit. So quantum merit is a principle in the law of restitution, and the tribunal said that essentially there was an implied request by the charterer for services outside the scope of the charter party, and there was in exchange an implied agreement from the charterers to pay for those services at the current market rate. Alternatively, the owners said that they were entitled to user damages. Those are damages to compensate owners for the loss of the right to use the vessels, which was a valuable right, whether or not the owners would actually have used them during the overrun period. And the tribunal also said that whether the owners would have actually used the vessels to charter them out should be disregarded as being either too remote or something called res inter alios acta, which is...
It's essentially shorthand for none of your business, basically, right? It's matters between other parties, I think is the Latin translation. So it is essentially, they're basically saying this is just not something that factors in to the calculation of your loss. You limit the calculation of the loss to the affairs of the two parties, what has been agreed between the two of them. And then anything, you can feed in external factors when they come into, questions of mitigation, for example, but normally it doesn't come into the calculation of loss. And I think it's particularly significant here that I think there was an independent contract, the MOAs, which said that the owners did not have the right to take the ships back to the market. But it was also admitted by the owners, it was common ground that anyway, they would not have chartered them. And I think that there's something there that's interesting. And I think it feeds into perhaps some of the discussion we might have later on about some of the arguments that come up. But it seems to me that there's one thing to say that there's a contract with a third party preventing me from doing something, and quite another saying, I agree, though, in any event, I would not have done it. Because, technically speaking, there's nothing preventing you from breaching that contract. There's nothing necessarily saying that a consequence of, that breach would have been that the MOAs would have been rescinded, for example. So that, again, English contract law is quite practical. It subscribes to this notion of, an efficient breach, that it's up to you essentially to breach a contract if the consequences of that breach are tolerable given the benefit of breaching it. It doesn't sort of take a more sort of doctrinal, principled view that you should punish people for breaching contracts generally, regardless of the commercial realities of whether it was worth doing or not. And so as a result of that, it seems, for someone looking at it from the owner's perspective, you can see an argument saying, well, hold on, this is nothing to do with us. This is essentially whether I want to breach that right, that sort of obligation I have under the MOAs is a matter for me. It's not a matter which really you can bring up against me. But the fact that here they have admitted that in any event, that we would not have gone to the market, we would not have found a different charter, seems to be quite relevant in terms of what, how the facts played out.
Yeah, and Lord Justice Mayles in his judgment, he focuses on this principle, this res inter alios acta principle. And I think the word that kind of stuck in my mind when I was reading that is collateral. What we're talking about here are certain collateral matters that you disregard for the purposes of assessing damages. And it's with that mindset, I kind of completely see where the court is coming from in this case. And it brought to mind before we got into the discussion of the alios, that was the case that immediately came to mind for me, because if you have a contract, in this case, owners and charterers, there's certain facts and knowledge that each of you have about your intentions going into the contracts, what you've agreed, what the contract entails, what you've signed up to do. And then there are factors that you don't have any awareness of. As owners, you don't have to tell your charterers what you intend to do with the vessel next. The owners could have entered into a very long-term, lucrative, multi-year time charter on the back of this. And it could have had some termination provision in it, that if the owners did not deliver this vessel into that next charter within 2 weeks of it supposed to be starting, those other charterers, nothing to do with the current charterers, could terminate that long-term contract and lose out. Now, this is the alios case, in whether in that situation the owners should be able to claim from the present charterers that really huge loss that they have potentially, they have suffered, as a matter of fact. And the court in the alios held that no, that's a matter that the charterers do not know anything about. They have no control over whether the owners enter into a subsequent contract. What they do know is that if they hang on to this vessel for a period of time, let's call it 2 weeks after when they're supposed to, that is a period of time within which both owners and charterers can see, okay, I know how much damage I've caused. And then you can peg that to the market rate. And if it's higher than the charter rate, that acts as a disincentive to charterers to do this. So, it's measurable. It's understood. It's kind of within the bounds of understanding. And I look at this case as well. It's almost taking that alios principle of collateral issues that, the owners may be intending to do subsequent to the contract, and saying, you don't worry about those. Those are collateral to the assessment. And that's what this case kind of all goes to. So
the alios has certainly cast a very long shadow. And I think it was controversial when it came out, and it's still controversial, all these years afterwards. I think it's probably worth just giving a very brief overview of the facts there, because it arose out of a very particular set of circumstances. And it happened in the context, as many big shipping cases do, of a war, in that case, the Iraq War. So in February 2004, the market index essentially for the cargo in question was around 5,600. And the Iraq War happened, leading to, the invasion was on the 20th of March, I think, 2003. So sometime before, obviously, that a year before this. But what basically on the back of that, what happened was that the really high market rates started to collapse. So they reached 2,400 by the end of May. And normally that shouldn't cause too much difficulty, because people essentially negotiate charters not that far out. So you actually get all this priced in. But in this case, it was material, because in the alios.
We're talking about the alios case.
In the alios, it was, I think the redelivery date was the 2nd of May. And, there were some delays. Crucially, I think also the delays were not on account of, say, an illegitimate voyage. It was accepted that it was a legitimate voyage. And instead of being redelivered on the 2nd of May, it was redelivered on the 11th of May. But the owners in that case had agreed a follow-on charter, which had a cancelling date of the 8th of May. And that charter was obviously at a significantly higher rate. That was now the going rate because of the collapse in the market. And so when it came to them sort of renegotiating that, they had to take a big hit on the rate. So they were able to sort of renegotiate a date late down the line. But because of the sort of rapid change in the market, they actually ended up losing very significant sums of money. And they actually had, over the lifetime of that charter, which was a very long-term charter, losses essentially of 1.35 million. But when it came to negotiating to close that case, the charter said, well, hold on, the standard rate, the standard measure of your loss is the difference in the market rate for the period of overrun. And yes, the market has fallen, so you're entitled to some compensation, but that number is 150, 160,000. It's not $1.5 million essentially. So that's really the issue that the owners then took to arbitration, and we went all the way up to the House of Lords. And in the House of Lords, we have this very sort of contested judgment where people are still talking about what exactly was decided, because there are a number of judgments which, in some extent, seem to be incompatible, all saying, all reaching the same conclusion, more or less, but for very different reasons. And that is a judgment, specifically the judgment of Lord Justice Hoffman, is seen as either seen as revolutionary or seen as reaffirming what was always the position, depending on who you ask. But that was a judgment, I think that's fair to say, has been quite controversial and is still being discussed today and very heavily featured in the discussion we'll see throughout all three levels of adjudication in this case. So I think that's probably just enough context on why the Achilleas was relevant. But I think the key point was a very special set of circumstances leading to a loss that was a lot more significant than would normally be expected. And in that case, even though it was essentially agreed that loss had been suffered, the question was whether it was too remote to be recovered. It was the case we have here in the Skyros and the Agios Minas is actually slightly looking at it from a different perspective. It's saying, has there been a loss at all? Not, has there been a loss that may be too remote, it's too much, or it's so high in terms of quantum as to become something entirely different.
It's interesting, but I think of sale of goods as well, and you've got the Doric Valor case that's referred to in this decision, where a cargo owner can still recover the value of the damaged goods or be compensated for the damage to those goods, even if they have been paid in full for those goods. And so they haven't actually suffered a financial loss, but the goods themselves were still damaged and they can recover for compensation for that damage. So it is possible to end up in, arguably a better position than you would have been as the non-breaching party. And I don't think the law struggles with that. And you're quite right to bring up the debate in the Achilleas, and that it still has some controversy to this day. And it'll be interesting to see if this decision goes up further. But the way that the court unanimously here in the Court of Appeal has dealt with it is to try and say, well, look, there are certain factors that are just collateral to the assessment. And so, that's, we'll get into it a little bit more in a moment. But before we did, Andriy, I just wanted to touch on this concept of legitimate and illegitimate voyages at the end of a time charter. Can you tell us a little bit about those? What are those about?
Yeah, absolutely. So this was essentially a collateral issue in this case, but still there was an interesting discussion about that. So a legitimate voyage in this context means that basically the charterer gives an order to the ship owner, and at the time when the order is given, there is no reason to suspect that it may actually overrun the charter period, but something happens and the vessel is redelivered late. An illegitimate voyage is where it is clear from the beginning that the charterer's order will result in the vessel being redelivered late. So the difference is that where the charterer gives a legitimate voyage order, the owner is of course bound to follow it as per the terms of the charter party. When it comes to an illegitimate voyage order, the ship owner is not bound to follow it. And I think there was an indication obiter in the Court of Appeal judgment that such an order may actually be repudiatory. And as is the usual rule, in the case of repudiation, the ship owner may either accept the repudiation and bring the contract to an end and claim damages, or alternatively, the ship owner may reject the repudiation, affirm the contract, and then also claim damages.
So in both cases, the owner can still recover damages at the market rate for the overrun. Yeah. But the real difference there, and as you say, it's not the point that then turns on this case, but I think it's a important issue to be aware of in the context of these types of cases, is that if the orders are illegitimate at the time they're being given, the owners can say, we're not going to follow them. So the owners doesn't have that. They do not have that right to reject the orders if they are legitimate, in the sense that when the charterers are giving them, it's expected that voyage will complete within the time charter period. Because as we know, time charterers often charter their vessels out again on other voyages to other charterers for voyages, kind of carving up the time period into subsequent voyage charters that then themselves are not, it's not their own cargo. They're chartering it out to another company who wants to carry cargo for a shorter period of time. So yeah, and you know, there's different factors in there as well, but I just thought it's useful to touch on that.
I think chartering a vessel is like hiring a car. That's an analogy I think a lot of people use, but I think one of the issue with illegitimate and legitimate voyages is that I think it makes it more akin to, say, a chauffeur-driven car, right? If you hire a car, it's basically a variable charter. You have to drive it. You basically are responsible for, fueling it and all that. You have it, you pay for the time you use it. But when it comes to a time charter, the idea is that you don't actually have possession of the vessel, which is quite significant. So you're entitled to give orders to the vessel, but, it still has a crew on board and a captain who have been placed by the owners. So, and this is something that sort of, I think, all the judgments in this case touched upon peripherally, which is that the owner is not entirely at the charter's mercy. If you get an order which you feel is pushing you beyond the contractual rights, you're entitled to say no, right? You're entitled to say, sorry, hold on. This voyage will, these orders will take us beyond the maximum point, and I have, follow-on business or whatever. And it's not really something that anyone has fixed on, but it has featured in every judgment, sort of, in terms of hints at the fact that this is a factor that feeds into it, right? You're not entirely essentially at the mercy of the charters in that respect. You've elected, basically, you've chosen to carry on doing that business. And I think that takes away some of the sympathy with the owner's position, I think, in some cases. Obviously, not enough here to sort of completely change the outcome, but it's definitely something that seems to have featured as part of the thinking.
Yeah, I wanted to add that, as I mentioned at the beginning, so one of the arguments put forward by the owners was that they were entitled to what's called user damages. And those damages are usually awarded to a party who has been wrongfully deprived of possession of their property. So, for example, I think that this was an example given, I think, either in the High Court or in the Court of Appeal. You have a number of chairs in a room, and someone just comes into the room and sits in a chair. You don't suffer any actual financial loss, but at the same time, you have been deprived of the use of the chair, and damages are awarded to compensate you for that. But as Emmanuel pointed out, in the case of a time charter, there's a contractual agreement all the time in place, and the charters are never really in possession of the vessel. So even if the charters give illegitimate voyage orders, it is always up to the owners to either say yes or no. So there really is no deprivation of possession in the sense which is required to award user damages. And that's why the High Court and the Court of Appeal were unimpressed with the owner's arguments relying on user damages.
Well, I think the Court of Appeal ended up slightly differently on that. I think in the end they did see that some of the sense in that argument. I think it did feature very heavily in Mr. Justice Bright's sort of rejection of it. He was quite uncharitable about some of the arguments brought in the arbitration, called them make weights. But I think, I think fundamentally, faced with what was quite a complex issue in which there was not necessarily any clear answer, the instinct obviously of the parties was to try and bring in other collateral issues into the argument, to try and sort of hang their chosen interpretation of what the outcome should be on those. And obviously the High Court was not impressed, saying essentially there wasn't possession, as you said, but also saying essentially that, look, this is not a wrongful situation. You have a contract providing for this use, and all you're seeking is a top up on your hire, essentially, on the rate you've agreed should be payable. And to get that, you need to prove some loss. So I think that the fundamental issue for Mr. Justice Bright was that, yes, we do have all these proxies for assessing loss. We do have this standard measure of recovery. But if in the event it's proven that those are displaced and there hasn't been a loss, they won't allow you to recover losses which have not actually been suffered.
Yeah, exactly. So getting to the nub of it, the way this went was that the arbitrators did decide in favour of owners and granted them substantial damages, not nominal damages, on the basis of the market rate. It was then reversed, as Emmanuel says, by Mr. Justice Bright, who found for the charterers, and then it's before the Court of Appeal here, which, getting to the decision, it went in favour of owners, as you may have picked up from our discussion so far. What was the main legal principle that the court relied on here, Andriy, and why?
The main principle that the Court of Appeal relied on was something we mentioned earlier, this Latin maxim of res inter alios acta, which is a shorthand of, as Emmanuel very eloquently put it, none of your business.
I like that.
So I think that there are two ways to look at it. So if you take the High Court's decision, Mr. Justice Bright focused on the actual loss suffered by the owners, and in that case there was no loss, and on that basis he rejected the owner submissions. But the Court of Appeal adopted a policy-centered approach. So that approach is basically aimed at promoting legal certainty and avoiding the need to litigate and arbitrate. It basically allows the parties to settle their accounts quickly without resorting to disputes. And that approach is that whenever there is late redelivery, the law puts in place an assumption that the owners are entitled to be compensated by reference to the market rate of hire. And even if, as the circumstances of this case demonstrate, the owners have not suffered any actual loss because they have not been deprived of the opportunity to use their vessel in the market, they are nevertheless entitled to recover the market rate of damages. I think it ultimately boils down to policy reasons. It might seem unjust to charterers in the circumstances of this particular case because, well, you could say that owners are getting something for nothing. They haven't suffered any actual loss and they will be awarded substantial damages. But on the other hand, it promotes legal certainty, and that is a valuable concept. So yeah, it basically is a compromise.
It certainly came through in especially in the Court of Appeal judgment that, sometimes you have to accept a certain level of inefficiency, right? And it's the policy arguments, which you very rightly point out, I think really come through in some of the comments made in respect of, for example, I think one of the examples was, if this isn't the case, if there isn't a certain measure that we adopt and we say this is what will apply, then essentially everyone will push through to arbitration just in the hope something will come out in disclosure. And I think, so obviously the court seems minded to try and promote certainty and avoid a situation where there's just, you keep having to push through just to get to the answer to find out what happens. Fundamentally, though, I'm not entirely convinced by that. I mean, we've obviously been very innovative here. Andriy is Ukrainian and I'm Greek, and Andriy is for the owners, I'm for the charterers. So we've taken things the wrong way around, one might say. But
so how do you feel about this?
I think fundamentally, right, as charterers, you would have some difficulty in explaining to a client, right, why owners are walking away with a loss they agreed they never suffered. And there is an argument for legal certainty sometimes, and you have to accept that there's a degree of certainty you're never going to reach. So you want to simplify matters and get to a certain conclusion. But at the same time, this was a case where it was part of the agreed facts. And the cases where that is, the case will actually be quite limited. It's not, this is, again, like the Achilles, a very special set of circumstances. It is not often that it's accepted, both because there is a secondary contractual obligation that the party cannot recover or has not lost a valuable opportunity, and in any event would not have taken that opportunity. That's not a given. And I think the reality is that, parties might want, if it was more open-ended, to push matters, to try and go to disclosure and see if anything comes up. But that's a rather expensive roll of the die. I think by the time you get there, quite a lot of money will have been spent. I'm not sure that in reality that many people would really have the appetite to go down that route unless there was something that, gave them pause for thought, that said, well, hold on, we think there's something going on here. So in this particular case, it was established. And one of the beauties of English law has been its pragmatism that, yes, we don't adopt a doctrinal point of view. And yeah, we do want to promote certainty, but we will not give you something for nothing, I think is one of the key underlying themes, that if you cannot prove your loss, you will not be able to recover something. And I think I think a charter is likely to be aggrieved in the same way that the charter is aggrieved with speed and consumption claims. When, very often you can prove that this ship is not performing as it should, but because you cannot precisely quantify it in accordance with what the charter party says, you end up in a situation where you as a charter cannot prove your loss. And because of that, you cannot get a recovery. Right? You cannot recover a loss you cannot prove. And that does strike, I think, charterers, something that's deeply unfair. And I do have a fair amount of sympathy for that. It feels.
Yeah, I see where you're coming from. And I think it's a good point to make. One element of this that comes to mind when I hear you describe that, and it's something we touched on earlier, is this concept of legitimate and illegitimate voyage orders. I don't have as much sympathy for the charterers if they're giving illegitimate voyage orders. If you know that this voyage that you're going to enter into right at the end of a time charter period is definitely going to run over the redelivery date, then you should have to pay at the market rate, irrespective of what the owners intend to do with the vessel. For me, that seems like a very reasonable principle, and I don't have any sympathy for a charter in that situation. If the market has risen, of course, and if the market has fallen, I still think you should pay the charter rate, which is the case. In the legitimate voyage order scenario, where it is reasonably contemplated that the charterers can perform that last voyage and redeliver within time, and then there's bad weather, or there's something that happens, I have more that's outside the control of the charterers. I have more sympathy for the charterers in that scenario, in which, I could see them arguing, well, we should be allowed to continue to pay at the charter rate, not be subjected to market damages. But on the flip side, owners would say, well, you had it for this period of time. If you had given it back, bad luck, then it needs to be some allocation of the risk of delays here for bad weather or what have you, and it shouldn't be on us because we've agreed a certain period of time. And if it goes over, even if it's not your fault, charterers, you should have to pay the market rate. I think though, where I see a lot of force in this decision, if I may say, is if you start taking into account what owners are going to do with the vessel after this charter period, then it opens up a world of scenarios. In every case of late redelivery, you would have this debate going on about what did you intend to do with the vessel thereafter. You would have disclosure requests. You can imagine it. Put yourself in the shoes of handling this type of case. You would be pushing as charterers to find something that contemplated that the owners weren't going to enter into another charter, or they were going to enter into a charter at a different rate, or, that they had some subsequent charter agreed, and that charter should be the measure for the market rate instead of just an open market measure. As Andriy said, this decision gives a lot of certainty between the two parties as to what the state of affairs is. And yes, there can be a debate about what the market rate is. In this case, the parties had managed to agree on that, but sometimes that's the issue that you're debating, what the market rate actually is, and that can create an interesting debate sometimes. But other than that, like if you run over in these situations, then you're going to have, if you're the charter, you're going to have to pay at the market rate. What do you think about it, Andriy? You think the court got this right? What's your thinking behind it?
I think that the decision of the Court of Appeal is not without controversy. But I think we could probably all agree that this decision promotes certainty and certainly saves time and costs for owners and charterers. And I think that ultimately this is a very practical result.
Interesting. I've got to say, when I hear your descriptions of both of you, and I suppose I'm sitting in the middle here in a way, it does sound to me like a case that could go higher. I think this could go to the Supreme Court. I've heard Andriy and Emmanuel both refer to policy reasons underpinning a judgment. Whenever I hear that as a main factor for a decision, it concerns me. A good former colleague of ours used to make that point regularly, that judgments need to be based on legal principles, not so much policy decisions. And if they do, that's when there's a lot of room for debate. And given this kind of builds on the alios, and Emmanuel makes the point the alios is still controversial to this day, it will be very interesting to see if this goes up. And it's one, maybe it's a judgment that on its face reads in a succinct, clear, I thought persuasive way, I think described as compelling by Led Justice Andrews. Maybe there's more to it, and we may well be hearing more about this decision down the track. So yeah, any final thoughts, gents?
I think this is definitely a case that would be very interesting to hear more on. I think it's one of those cases which sort of strikes a nerve. Both sides have a really solid elevator pitch as to why they're obviously right. One side is basically saying, look, the law doesn't always give you a sort of perfect measure of compensation. Sometimes you have to cap your losses and just approximate it because that is more efficient overall. And there's this standard measure and we're just applying it. And the other side is saying, but okay, hold on, that standard measure is just there to act as a proxy. If in the very specific set of circumstances where you cannot get that, when it's clear you were never going to recover that, you shouldn't be able to get it. So it's easy to see that both sides are very persuasive, and it's a case that really touches on a lot of core foundational issues of contract law. So I hope we get the chance to hear more about it in the Supreme Court if the parties have appetite.
Yeah, if they take it further. But going back to your point right at the outset, Emmanuel, this is the kind of case that has consequences for other areas of law. It's not just limited to a maritime context at all. And it's the point that Lord Justice Coulson makes in that as he was reading through the reasons given by Lord Justice Mayles as he cites here, he was thinking that there are other instances in which this type of principle arises, say where homeowners suffer some form of damage and the homeowners decide not to repair, or they don't actually suffer some actual loss of some kind, and yet they still claim damages for the costs of repair. You're still entitled to those damages for the repair costs, even if it's established that you don't intend to or won't repair the house. I think that's where, some of these principles could be fleshed out more at a higher level, perhaps. around the distinction between kind of mitigation of damages, and then what are factors that you take into account in assessing damages in the first place. There's more to be said around this. I found this a persuasive read. I really did. And I think it sits with the alios, which is, whilst controversial, still a decision of the highest court of this land. And I can understand the reasons for it. If you open this up and took the other position, Charter's position here, it does lead to an opening of debate and controversy in these types of cases moving forward. And from a practitioner's perspective, it would create a lot of complications. So I think the decision's attractive, but from a legal perspective, looking at some of the authority here, I can see why it sticks a little bit.
Yes, I actually wanted to touch on that very briefly. So it's interesting that you should mention the application of this decision to other areas. And so interestingly, Lord Justice Mayles himself, at paragraph 48 of the Court of Appeal judgment, refers to the case of the Doric Valor, where a bill of lading holder was entitled to recover damages for goods which were defective, even though the bill of lading holder managed to actually sell the goods to his sub-buyer at a profit and thus suffered no real loss. One wrinkle.
We were discussing this earlier, weren't we? And yeah.
One wrinkle, if I may say so, and I think for the moment I am taking my owner's hat off. I think I can see that a certain distinction can be drawn between this case and the Doric Valor, in the sense that in the Doric Valor, the goods in question were just generic goods, and the bill of lading holder could have easily procured replacement goods, sold them at the profit, and kept the contractual goods, the defective goods. In this case, in the Skyros, the situation is just principally different, because the main contract, the charter party, and the onward contract, the MOAs, the sale of the ships, were for the self-same goods. So the ship owners, by entering into the sales contracts, were effectively prevented from obtaining replacement goods. That is to say, they couldn't have just gone into the market, bought replacement vessels, and sold them to their buyers. So I'm afraid I don't see how the Doric.
But if you take into account, if you suddenly open it up to what the owners had done, right? And in this case, they'd entered into MOAs to sell the vessels. If you bring into the analysis what the ship owners did, if there was then a termination provision in those MOAs, if there's late delivery into those purchases and the buyers could walk away if the sellers, the owners, were late, and the market price had dramatically fallen for the value of vessels, such that those owners suffered a monumental 10 million loss or something, should you be able to bring that claim against the charterers for being 2 weeks late on a time charter?
No, of course not. I think that's the beauty of this decision. It takes a very practical, pragmatic approach. It basically assumes, or takes it as a legal axiom, that when charterers and owners enter into a charter party, they both understand that if the vessel is redelivered late, then the measure of compensation to the ship owners is market rate, if it has reason, subtracting the charter rate. So I think this should be approached from this perspective. So that this from the very practical perspective, that there are certain sort of rules of the game in place that all the participants subscribe to.
But that's a very interesting though, right? Because at that point, it seems like you're almost elevating this to something akin to demurrage, like liquidated damages, where the parties agree this is what's going to be paid. But I'm not entirely clear that it is the case that, parties really have incorporated this into their thinking as yet. Regardless of what the circumstances are, you're essentially going to be able to recover this, almost like liquidated damages, subject, of course, to having to assess the market rate and so on and so forth. So I can see the sort of injustice of it somehow biting. And I think it really has, again, shadows of that, Achilleas controversy, where I think Lord Justice Hoffman's judgment, was basically saying, or has been interpreted as saying, that foreseeability, which is sort of the touchstone of remoteness, is just a shorthand, an approximation of the rule. And the underlying rule is what the parties can be objectively taken to have assumed responsibility for. And I think the same thing can almost be said about this decision. It's essentially saying it's the battle between whether this orthodox measure of loss is a standalone, as you said, Andriy, axiomatic rule, or whether it is just a useful shorthand that will apply in 95% of cases. But when the facts can point otherwise, it's not something that the courts will apply completely blindly. But it's definitely very interesting.
Yeah, just very briefly replying to that. So it seems that the Court of Appeal has basically closed that possibility of those 5% of the cases being heard in arbitration or in courts. So basically, they have created what we call an irrebuttable presumption that even if there is no real loss, the owners may still recover the market measure of damages.
And P&I clubs everywhere opening champagnes at that news, of course. That now at least it should make things simpler for case handlers. It should make things simpler for insurers, for sure. But I think it will leave some people feeling essentially done over. Yeah.
Interesting, guys. Well, look, let's leave it there. I'm sure we could say a lot more about this decision. Clearly, there have been a number of topics to delve into. I really enjoyed the conversation. Thank you both for coming along. Thank you, everyone, for listening in. I hope you've found this interesting, and if you've stuck with us, well done. If you'd like more information, feel free to contact any of us here. I'd be happy to get into it if you've got a particular issue on your hands. Thanks again for listening in, and until next time, take care.